Mr. Moore, I am sure that you must have heard my comment. When opposing counsel came to the podium, I started off with a question that I said I should have asked you, but your time was up, and I was waiting for you to respond. And now I am asking the question, what is your response to my inquiry that I made to opposing counsel pertaining to, and at the time I talked about the Moscone Act, that the legislature enacted it with the aim of protecting economic activity, collective bargaining, and I haven't heard anything from you on that issue. So please respond to the question and don't ignore it or evade it. As I mentioned earlier in my question from the student.
Justice Kennard, I think you're correct, and I think that the legislature adopted the Moscone Act with that in mind, just in the same way that the National Labor Relations Act, which similarly protects a right of access over state trespass law, does the same thing. They're both economic regulations that abrogate, on a partial basis, common law rules.
One last question. I realize that both sides have paid a lot of attention to whether or not we are dealing with a public forum. Now, let's assume that this court were to decide that there's no need to reach the public forum issue. I presume, and this is simply for the purpose of oral argument, I presume that if this court were not to decide the public forum issue, and let's further assume that you were to win, you would take that win, right? Irrespective of no decision on public forum.
The answer to that question is yes.
Counsel, do you think that the time, place, and manner, the reasonableness test, however it's fleshed out, of the time, place, and manner restrictions, which you acknowledge businesses can have reasonable time, place, manner restrictions, does that standard of reasonableness track what's in the statutes, or is it something else? In other words, I think 1138.1 is pretty strict, in the sense of it's a pretty high showing. So can a business get an injunction based on its own restrictions that are not at that elevated level? In other words, having people walk up and down the produce aisle isn't obviously causing, I forget the language, substantial damage to the property or anything like that, assuming they're doing it peacefully. But we still wouldn't want to allow that. So I'm wondering how you close that gap.
Well, I think in most cases where that's occurring, where there's a violation of time, place, and manner restrictions, and the employer can show that this has a tangible effect on its property, that customers are in fact turned away, not hearsay evidence of that, but actual evidence of it, then the standard would be met. But it's important to note as well that this is one remedy among many that an employer has. They have civil remedies. They can seek damages. And crucially, because this is at the core of the purpose both of the Federal Norris-LaGuardia Act and of 1138.1, they can call the police. And that's part of the requirement under 1138.1. If a business has time, place, and manner regulations, those
call the police. What is the police supposed to do? Here the police said they're not going to do anything unless there's a court order.
Well, they didn't exactly say that, Justice Liu, but if this is a criminal trespass, if there are time, place, and manner restrictions that have been adopted that are being violated, then the criminal trespass statute is an option for a business owner.
So Officer Krumke, who shows up and finds a bunch of people picketing, and a business owner who says, trust me, they aren't supposed to be here because my time, place, and manner restrictions are valid under a prune yard, we really think Krumke's going to start arresting people?
Well,
it seems a little speculative.
I would only note that the same rule applies on public property. If the government wants to has time, place, and manner restrictions in a labor dispute, the government would need to call the police, and the police would enforce that rule. That was the purpose.
So your answer to my question is yes?
Yes, we can trust the police.
And Mr. Moore, your time's expired.
Thank you very much. And thank you to you all.
Thank you. Matter submitted.
All rise.